In this video, I'm going to take a look at something that's causing increasing problems for employers and indeed employees, and that is the inappropriate use of social media by employees. The problems that can arise from the widespread, prevalent use of social media include making adverse remarks about colleagues, stalking or bullying comments, negative comments about the employer or about the company, and sledging or bad-mouthing the boss. Questions that will need to be addressed from time to time will include: can the employer discipline the employee for what goes on outside work? Are the comments likely to negatively impact on the employer? Is the employer likely to suffer damage as a result of the comments? In other words, reputational or other damage. And has the employer a duty of care in respect of comments made by one employee about other employees? There's a wide range of cases, most of them at the moment coming from the UK over the last number of years, dealing with this whole question of social media and the use of social media by employees. It is becoming more common in Ireland, and there are more cases coming up. But for the purposes of this video, I'm going to have a look at some decided cases from the UK, various tribunals and courts, because they are useful and will point to the issues that arise. This case, Taylor versus Somerfield Stores Limited, 2007 case. This was a case where there was a bit of play acting involving an employee with a pile of carrier bags stuffed into another bag and striking or messing around with other employees. The video of this conduct was put up on YouTube. The employee then was dismissed for gross misconduct for posting inappropriate film footage onto the YouTube website, which brought the company into disrepute. That was the company's finding. However, it was only on YouTube for 3 days and only viewed 8 times, including 3 times by managers. A Scottish employment tribunal found that the dismissal was on the basis of the employee's genuine apology. The absence of any evidence the employer's reputation had been brought into disrepute, and a finding that the sanction was too harsh. An Irish case is the one involving Emma Kiernan and Aoife Limited. Miss Kiernan made a number of profane comments about her supervisor on the social networking site Bebo. The EAT held that the dismissal was disproportionate, even though the employer acted fairly in its procedures, and the EAT felt the comments deserved strong censure. So clearly the EAT were happy enough if Miss Kiernan had been sanctioned or penalised, but felt that the penalty of dismissal was disproportionate and excessive. Another UK case then is Taggart versus Teletech UK Limited. The Northern Ireland Industrial Tribunal held that the dismissal of an employee for posting obscene comments relating to the promiscuity of a female colleague on his Facebook page was reasonable and fair. This was on the basis that it was a breach of trust and by the employee, and also a form of bullying behaviour, I understand. Another Irish case then is Aoife O'Mahony versus PJF Insurances Limited. A director of the company, the employer, was shocked to discover that both herself and the company were described in disparaging terms. Aoife O'Mahony was dismissed for gross misconduct, and the employee or the Employment Appeals Tribunal found that her posting of these electronic messages on the Facebook page amounted to a breach of trust of such significance as to render her untenable or her employment, and the dismissal was justified. The Dante's Inferno case then in the UK was one where the claimant was dismissed for making posts that compared working in his employer's workplace to Dante's Inferno. The employer's social media policy did warn employees to avoid making posts that could damage the employer's reputation or be viewed as bullying and harassment. The Employment Tribunal concluded that the employer was entitled to dismiss based on the potential reputational damage caused by the claimant's posts. So what do you do if you are an employer? Well, if you're an employer, you need to have a social media policy, and you need to bring it to the attention of your employees. There's no point having a policy, obviously, if your employees are not aware of it and are not familiar with it. You need to ensure fair procedures in any disciplinary procedure that you might embark on. So your procedures do have to be rigorously fair, and you must ensure that there's a fair sanction if you are imposing a sanction, having carried out a disciplinary procedure. You need then to take all of the circumstances in each situation into account. For example, is it a one-off incident or is it repeated behaviour? Is there reputational damage to the employer, or is it just something that's silly and is unlikely to damage the employer? Is it a breach of trust or confidence? And, which goes to the root of the relationship between employer and employee. Remember, both the employer and employee are entitled to enjoy confidence in each other. And if that confidence or trust is broken, well then, it could be clearly argued that this is a breach of contract situation, and the employer would be justified in imposing a serious sanction up to and including dismissal. My name is Gorry. I'm a solicitor in Enfield. I do quite a bit of employment law. I hope you find this video useful. If you do, you might just give us a thumbs up down below, or subscribe to my YouTube channel, where I have a lot of videos about employment law and small business and all sorts of law in Ireland. Thanks for watching.